Good morning. Our next case is Kinsley versus Ace Speedway Racing Limited et al., and we will hear from the appellant.
Mr. Chief Justice, Associate Justices, and may it please the Court. I'm Ryan Park from the North Carolina Department of Justice, representing Secretary Kinsley in his official capacity as head of the Department of Health and Human Services. I'd like to reserve 5 minutes for rebuttal. This case takes us back to a difficult time in our recent history, just a little over 3 years ago, when the world was suddenly thrust into crisis. In the spring and summer of 2020, a novel and fast-spreading virus was sweeping the globe, and the executive branch leaders that our people elected to protect them during emergencies, President Trump on the national level and Governor Cooper here in North Carolina, were forced to make a series of excruciating decisions in real time based on the best available information at the time between saving lives and preserving our healthcare system and temporarily restricting economic and other social activities. One of those decisions was the Secretary's choice to issue an abatement order pausing Ace Speedway's ability to host what were, at the time, some of the largest mass gatherings occurring anywhere in the country, and which would have been illegal virtually anywhere in the country, including under similar executive orders issued by all of our neighbors, Georgia, South Carolina, Virginia, Kentucky.
Counsel, I have a sort of a threshold question about the abatement order. So the order repeatedly references the governor's emergency order. Under the Emergency Management Act, there is an enforcement provision. And what that provision provides is that the violation of an emergency order is a crime. There's no civil enforcement mechanism. So I have a concern that the order of abatement is essentially an attempt to enforce the governor's order through some civil mechanism, even though the legislature didn't give the governor the authority to enforce his order civilly. Can you help me with that?
Yes, Your Honor. So, Justice Allen, nothing in the Emergency Management Act says that the remedies available to the governor or their enforcement mechanisms in the act are exclusive. And of course, a common set of facts can violate multiple laws. That happens all of the time and be subject to multiple separate enforcement streams. So, for example, in the Emergency Management Act, one of the enforcement mechanisms is explicitly that the governor has the authority to order and direct local officials to comply with emergency mandates, to get individual affected businesses and individuals to comply with mandates. So there are, even within the act, there are multiple enforcement mechanisms. And here, what the Secretary determined is that as well as violating the Emergency Management Act, the conditions on the ground in the spring and early summer of 2020, where ACE was hosting multiple thousands of people in Alamance County and gathered together in one place, that independently posed an imminent risk to public health.
So just to elaborate a little bit on my concern here, if you look at, for example, 160A-175, that's the statute that gives municipalities the power to enforce ordinances. It includes a provision that allows criminal enforcement, but then it also lays out a set of civil mechanisms that local governments can use. I don't see that in the Emergency Management Act, and so therefore I have a concern that the legislature made a decision to limit the means of enforcement, and that the abatement order is to some extent an effort to circumvent that limitation.
Yes, Your Honor. So there are two separate points I'd like to make in response to that concern. First is, again, that I don't think that there's ever been any dispute that the Secretary has the authority to issue, or had at that time the authority to issue abatement orders limiting public health hazards, and that she made an independent determination.
So why is the governor's, so I agree with you that the Secretary could have issued an order under 138-20 without citing the governor's order at all. So if it's not an attempt to enforce the governor's order, why is the order mentioned throughout? And I'll point out that in the provision of the abatement order that deals with duration, essentially what it says is it's going to last while the governor's order is in effect. So it doesn't seem like an independent determination. That's my concern.
Yeah, I think it's perfectly permissible for the secretary to use as a basis for determining that there's an imminent health risk a separate source of authority. So if, for example, there was a risk of a salmonella outbreak at ACE's concession stand, and there was not explicit statutory authority for addressing a salmonella outbreak, the secretary could use her general public health authorities to abate the nuisance and to order that temporarily ACE's concession stand not operate until the health risk had been resolved. And I guess the broader point I'd like to make, Your Honor, is that that is a question of a statutory violation. It's not a fruits of labor clause claim. It's not a selective enforcement claim.
But if, well, I think it might be a fruits of labor claim, because if the abatement order is unlawful, then wouldn't, and it does in fact infringe on the ability of the Speedway to make an income, then couldn't it be then a violation of the right to the enjoyment of the fruits of one's labor?
I don't think the analysis would really shake out in that way, Your Honor. I think, well, first of all, this court has never said that a mere statutory violation is automatically a violation of the fruits of labor clause, but more specifically directed to your...
I'm not saying that. I'm saying where you have an order that places such severe restrictions on the economic activity of an individual or a company, that in that situation, if it's done so, if those restrictions are imposed unlawfully, that's what I'm getting at. It's not just any violation, but a violation that's aimed at restricting economic activity to a significant degree.
I don't think that it would be proper to avoid the direct constitutional question that's raised in this case, which is whether the lawfulness of that order as it pertains to the fruits of labor clause is whether it was rationally related to protecting public health, and not whether there's some claim that has not been made here that under the Emergency Management Act itself and the scope of the governor's authority under the EMA, Mr. Kitchen has forthrightly admitted throughout this litigation that he has not made a claim challenging the governor's and the secretary's authority under the Emergency Management Act to impose restrictions on businesses when there's a public health emergency.
I think what Justice Allen's getting at is if the government shuts down your business, saying, I'm doing so acting under this authority I have, and it turns out the government has no authority to do that, that you could bring a fruits of their own labor clause claim. That would be irrational for the government to do that. And so it would satisfy even, I think, the standard that you're articulating for this constitutional provision, which is rational basis. I have some questions about that standard, but let me take a step back. So do you agree that what we're looking at here is a ruling on a 12b6 motion? Is there any kind of dispute
yes,
that's the framework?
Yes.
Because you can see how at the very outset, it's kind of an odd situation. In most cases involving Rule 12b6, you wouldn't start out by saying, someone steps up at the podium and says, let me tell you about everything that's been going on in the world at the time this was happening. You just say, let's look at the four corners of the complaint and whether it alleges a claim. And I'm a little concerned that we need to keep in that framework, even though this is a case with a lot more going on in the world at the time this claim arose. So my first question to you is, I understand you to argue that there's sort of a federal rational basis claim that's very well settled, and that is also the test that applies to fruits of their labor clause. And I noticed in your brief, you sort of cited the cases that come closest to the federal standard, and you skipped over some cases like State versus Balance, which are kind of the most famous, fruits of their labor clause cases in our jurisprudence, and word it differently. So I'm curious, what's your argument for why this sort of conceivable hypothetical test is what was happening in some of the older kind of the paradigm cases of the past, these occupational licensing cases and things like that?
Yes, Your Honor. So there's a lot there. If I might just quickly wrap up the beginning of the discussion on Justice Allen's question, I think our position is this, that the government has enforcement discretion. And when there's a set of activities, a common set of facts that violate multiple statutes or multiple areas of law, then the government has the discretion to select among them. On the question that you raise, Your Honor, over the last 50 years, my understanding, in every single case that this court has resolved a claim like this one, a Fruits of Labor Clause claim challenging an economic regulation of a business, it has applied rational basis review. And yes, there are statements in some of the early licensing cases, in Harris, in Roller, and Balance, that suggest a broader scope of review and the police power argument that Mr. Kitchen is advancing here. But I could just read from Chief Justice Newby's decision in King versus Chapel Hill in 2014, a unanimous decision, and it says, "This court has long recognized that the police power of the state may be exercised to protect or promote the health, morals, order, safety, and general welfare of society, and then to be sustained as a legitimate exercise of the police power, an ordinance that regulates trades or businesses must be rationally related to substantial government purpose." And so our position is that these may have been highly contested doctrinal disputes more than 50 years ago, but over the intervening decades, they have been resolved in cases like King and Poor Richards and Tran.
Yeah, but even the standard that you just articulated is very similar to the standard in Balance. The only difference was, if you read Balance, it was evidence-based. So rather than saying, let us conceive, essentially as judges in evaluating your claim, what can we think of that could be the rational thing that sort of the fit that goes between whatever the government action is and then the legitimate government interest, that we will actually ask, what is the government interest in this case? And then we'll look at, was it reasonably necessary? It seems to be the wording that is used over and over again. Was the government action that's taken reasonably necessary to either protect or promote that government interest? And if you look at it in that framework, you really can't decide it on 12b-6. There's got to be some fact development in order to rule on the merits there. Do you disagree with that?
Yes, Your Honor, very much so. And I think as an abstract matter, that can't possibly be true. I mean, King was decided on the pleadings. In Poor Richards, it was summary judgment, but Chief Justice Exum made very explicit that the government is not required to put forward record evidence proving that the regulation advances its substantial interest. It's a legal question for the court. It's not always susceptible to resolution on the pleadings, but it can be. And here, I think this might help. I think the relevant distinction and the way to weave the cases together is to say that rational basis review in this context, it's not the same as the federal anything goes standard. There are additional guardrails that are put in place, and I would direct the court to the Poor Richards decision, again, a unanimous decision from this court, where I think the most meaningful constraint is that the regulations can't be a guise for economic protectionism. It can't be the government intervening in the marketplace to try to help one set of industry players, usually an incumbent powerful group, against new entrants. And when you do regulate a particular class of businesses, the court has said repeatedly, and this is from Balance, I believe, that there has to be some distinguishing feature of the business in question to justify the regulation. And that's a far more searching review than the general rational basis standard when the government is regulating a particular class of businesses. And so to take it back here on the distinguishing feature of ACE's events in May and June of 2020 is that they were very large. And this was a time, just 2 days prior to the issuance of the abatement order, the Secretary and the world received guidance from the Trump administration that large events, including indoor and outdoor sporting events, posed the very highest risk of spreading this disease in our communities. And one particularly salient point is that these very large events are not community-based. There's evidence in the record, this is in the preliminary injunction record, that 85% of the people who attended these races were from outside Alamance County, a lot of people from out of state even, because this was such a draw, because these things were not happening anywhere at the time. And that is precisely the kind of situation where, under that Trump administration guidance, the Secretary believed that it posed an imminent risk to public health.
So suppose, I agree with you, I think those guardrails are there. I don't think it's sort of the traditional modern federal rational basis. But examining those sort of guardrails that we have from the development of our jurisprudence over time, everything you just said, I mean, this is the concern I have about this case, is we talk about it being in the record, but none of that is in the allegations in the complaint. What the complaint says is, and to some extent you need to get some of the facts from the second of the two causes of action, but when you combine them together, that the Speedway spoke out against the governor, resisted what the governor wanted to do, embarrassed the governor essentially, and he ordered the government to target that particular business and shut it down when there were other similarly situated businesses engaged in the same sort of conduct and that went unregulated. And it seems to me that if they can prove that set of facts, if the standard at 12b-6, is there any conceivable set of facts, if they found evidence that proved that particular allegation, even under the sort of poor Richards and some of the more modern case law, that would be irrational and that claim would go forward. So why at 12b-6 stage can you dismiss this claim?
So I think there are two separate areas there. There's a factual question and a legal question. On the factual question, I respectfully disagree because on the face of the counterclaims, all these facts weren't available, but these were counterclaims and there was a complaint and a pleading that the counterclaims were in response to. And all the facts of the pandemic, and I made very sure of this, that we want to rely on here, were stated in the complaint itself and the accompanying affidavits from Secretary Cohen.
Hold on, can we do that? Because don't you have to take the allegations as true? And so can you look to the allegations that the other side made in one of their pleadings to decide whether or not, shouldn't we be looking at what was pleaded in the counterclaim in order to know what they want us to sort of in the four corners say, this is your allegation? I mean, that's what my concern is. I know it's a counterclaim, but they also denied a lot of those allegations that were made in the initial complaint.
That's fair, Your Honor. And I think there are areas of factual dispute, particularly relating to the selective enforcement, what other speedways were racing, what did the Secretary know, and how do they know it, essentially. But on the broader facts of the pandemic, there's really never been any dispute between the parties. The Trump administration guidance is a public record. The number of people that had died, that is all public record, and I don't think is really susceptible to reasonable dispute, even on the pleadings. I think the second part of your question relates more to the selective prosecution question than the fruits of labor. I think there are multiple reasons why that doesn't apply. And the first of which is that if you look at the counterclaim itself, this is page 142, I believe, it says merely that other speedways are racing and the Secretary is not enforcing it. It never says even that those other races have more than 25 people at them. Right, so that's a very obvious pleading deficiency. But more broadly, what this court's case law says is that there has to be conscious discrimination, meaning that the Secretary, to state a claim here, the Secretary must have consciously chosen to target a speedway based on its protected activity while leaving everyone else who engaged in the same actions, in the same circumstances, alone. And they never there's no allegation even that the Secretary is consciously aware of any of their speedways, let alone that they were repeatedly violating the orders and bringing thousands of people together in a large gathering. And that's really dispositive because the selective prosecution claims are designed to be very, very rigorous. Mr. Kitchen's own authorities state that out. The Hastings case and the leading case on this is Armstrong. This is an 8-1 decision from the U.S. Supreme Court saying that actually pleading standards don't even apply in a selective prosecution claim, that it's a matter of proof, even on the pleadings, that you can't simply say, this is, the most common fact patterns are things like, I was stopped for speeding because of my race, and I aver on information and belief that other people who were speeding were not stopped, right? And you can't just say that and then get a discovery and sue the government based on your ticket. You have to say that, well, if I was speeding at 100 miles an hour and other people were speeding at 70 miles an hour, that's a relevant distinction that defeats the claim. And you have to show that and under federal law, it shows a matter of proof, so even taking that outside the pleading standards, but even within the pleading standards, that you have to show that the enforcement officials were aware of this disparate treatment and decided to persist in targeting someone in an unconstitutional manner.
Yeah, you've moved into the second cause of action, and I want to bring us back to the first. So even if you were right about that, for the fruits of their own labor clause claim, if the allegation was, essentially taking everything in that those allegations and all the reasonable inferences in favor of the claimant, that what's going on here is you have government officials who are petty and say this particular business is standing up and others are not. We want, let's single them out, let's target them, let's punish this business and make a point. And what I'm saying is that why isn't that? If there are facts that could prove that that's correct, why wouldn't that be enough to prove that what the action they took was not reasonably necessary to promote some public good in this particular circumstance, and then that would meet the test under Balance and its progeny. So you have stated a claim. Now, can they prove that once they get into discovery? Who knows? But at the very early stage of the case, it would move forward. You just don't, you disagree with that. You don't think if all of those things that are alleged there are all true, that this claim could move forward.
Again, I think there's a factual response and a legal response, if I may. I mean, the factual response, I think, is easier, which is that's not what the complaint alleges. The complaint alleges that there was public criticism of the governor's orders. Well, that's from our own complaint, and that is how the secretary was alerted to these violations of the governor's orders, and then that there was an enforcement action because the government was aware of a violation. And just to give an example.
But aren't those allegations that you made? Is that in the counterclaim? So again, just taking it back to simple 12b6 principles, we really can't take as true the state's allegations. We only are taking as true the allegations that have been made by the claimant, and the claimant here is the party that's asserting the counterclaim, even though it's part of a response to another affirmative pleading.
Right. Yeah. So on that particular point, I think it is. I think it's an essential part of the counterclaim that the speech was the reason why the action was instituted. And the legal point really is this, that is perfectly permissible. I mean, the U.S. Supreme Court has held out, this court has not said explicitly in this context, but we refer, of course, to the State versus Davis case from the Court of Appeals, that if someone is engaging in protected speech, criticizing a law, and then goes ahead and violates it, it's perfectly permissible for the government to, in its enforcement discretion, decide, well, that public criticism of the law is not what we're going at. We're going at the fact that we know that this violation of law is taking place. And so, for example, if I say, I have a Second Amendment right to bring a gun in this courtroom, I can stand outside the courthouse and declare that. But if I step inside the courtroom with a firearm, that is illegal, and I can be prosecuted for that. So there is a very salient distinction between criticizing the law and then going ahead and breaking it.
So I agree that's the doctrine for the selective prosecution of the retaliation theory. But what I'm getting at is for the fruits of their own labor clause claim, why would you need that? Because if they can prove that there were other similarly situated actors and there was no attempt to enforce there, and they're arguing we were targeted because of, and so on and so forth, all the allegations are true, plain, then the fruits of their own labor clause claim would be they can prove that it wasn't reasonably necessary to do it to this business, to promote some public good, because you would have been consistent in enforcing it against other businesses, and so there was an unreasonable or an irrational reason for the government to do what it did, which was some sort of pettiness about this person is challenging us, whatever the arguments you can infer from the allegations in this complaint, and that is enough to get past the pleading stage and get into discovery to see if that's true or not. You just think doesn't work.
So, well, if I may, I think that applying that logic to this case would really require the court to be blind to the broader context of what was happening at the time. Again, my understanding is that these were among the largest mass gatherings happening anywhere in the country, and the rest of society, we were all under these similar restrictions. The vast majority of businesses and other operations were complying with the law. And this was one of the few actors that was vocally, yes, protesting, and then going beyond protest and violating the law. And so I think even under that logic, I can't see how it would apply here and allow for discovery on these particular claims.
Wouldn't it be that everything you just said is the sorts of things that will come out in discovery? So at summary judgment, if their allegations aren't true, you're making the argument you're making right now, you win this case at summary judgment. But all the things you just described just aren't in the four corners of the counterclaim in this case. So we have to ignore that in deciding whether or not they stated a claim.
Well, I certainly agree that we would win on those facts on summary judgment. I guess what I'd say there is that This is not an ordinary notice pleading situation. We're operating under the Dominski standard, which requires more. It requires a colorable claim. And the way it's defined, as Your Honor knows, is very similar to kind of the federal Iqbal plausibility standard, which requires more than just notice pleading and giving bare allegations that my rights have been violated. You have to aver, substantial allegations to prove that this claim, not prove, but to show that the claim is plausible. I think given everything we know about what was happening at the time, this particular claim wouldn't meet that standard. And I see I'm eating in my rebuttal time. I guess if I could just make one last point that I think connects to this discussion, which is it would really be particularly inappropriate to award money damages to A Speedway in this context where everyone was under similar restrictions and the political branch has stepped up. And my understanding is that over $20 billion of funds were dispersed to North Carolinians, individuals, and businesses to help compensate for the financial hardships and the suffering that they endured because of these and other restrictions. I mean, to give some comparison, that's
Counsel,
roughly, yes.
I'm sorry, I know this is cutting into your rebuttal, but doesn't quorum say money damages is the appropriate remedy?
It says that if there's no other less restrictive remedy that is available to remedy the harm, then yes, it's an appropriate remedy. But that discussion, it doesn't say that money damages are necessarily the appropriate remedy. And I think it actually hints in the other direction, Your Honor, because what it says is, so that claim was an employment dispute. Someone was terminated and they want to be reinstated, and they also wanted back pay. And what the court said is it might be appropriate to allow order reinstatement on remand without back pay. It didn't say that it would be, but it contemplated the possibility that injunctive relief alone would be the appropriate remedy there. So with that, I'd like to reserve the remainder of my time for rebuttal.
Thank you, counsel.
Thank you.
We'll hear from the appellee.
Mr. Chief Justice, and may it please the court, I'm representing the appellees After 5 Events LLC and the Turners. My name's Chuck Kitchen. What we have here are three primary issues that have been raised. The first is a free of the laborers clause, second is selective enforcement. The third, which was just touched on by the state, is the least, what were they calling it, least intrusive remedy. I will try to address all three of those if time permits. First, I'd like to frame this argument a little bit. The state has filed a motion to dismiss based on sovereign immunity. Sovereign immunity was not mentioned in the argument, and the state has kind of ignored that. But it is a sovereign immunity motion. In other words, the question is, does the court have jurisdiction to consider this action? The short answer is, yes, they do. In quorum, the court held that sovereign immunity does not bar a claim based on a violation of our Constitution. In Dominski, this court did say the claim must be colorable. So that's where we get into this other argument. So with a colorable claim, all that has to be shown is that the claim is plausible, that it may be asserted given the facts and the law. What we have in this case is a Speedway, which was operating. It was ordered to be closed by the DHHS secretary for violating an executive order. Even though there is talk about this imminent health hazard, there was no imminent health hazard. It's simply a violation of an executive order. Justice Allen had brought up the issue about, can you do that? Can you use a executive order for the basis to have an order from DHHS which closed a business? Under Moose versus Barnett, this court said no. This court said, if you have a criminal remedy specified in the statute, then you must use that criminal remedy. Now, the state says, well, you know, that's just one thing. It didn't say we couldn't do something else, but this court has said, no, you can't do something else. If you have a statute that provides the remedy, that is the remedy you have. You can't just go off and do something else. What happened? The state went and ordered the sheriff. The governor actually had the sheriff called, sent letters to the Board of Commissioners and to the sheriff saying, go shut down a Speedway. And the sheriff said no. Said, I'm not going to do it. He went out, he talked to him, but he said, no, I'm not going to do it. I'm not going to shut down a Speedway. So what did the state do? Did they have the Turners arrested, which presumably they could do? The state has all kinds of law enforcement they could send out there. They could send out state troopers, you got SBI, you got all kinds of agencies. They didn't do that. Instead, they said, we're going to go and issue an order of abatement. We're going to do a civil remedy to shut you down for violating my executive order. This court has said that is not proper. This court has also said, in a case called Millay versus City of Durham, that it is important under the Fruit of the Labors Clause that you use the proper procedures. If you have procedures adopted, then you should follow them. You can't go off and do something else to shut down a business, to deprive someone of their employment, to keep them from working.
Counsel, the argument you're articulating now, which I think is following up on Justice Allen's questions about the validity of the abatement order, which is relying on the governor's emergency order. Did you have to plead that? Or in your view, is that the sort of question of law that when you say it was unlawful to do it, it's sort of incorporated into that allegation? Because I didn't see anything in the counterclaim that's articulating the theory you're describing right now.
We adopted by reference the previous part of our answer and counterclaim. And yes, we didn't go back out and restate everything, but yes, I will submit we did plead it. That's the other issue I want to get into. The state has said this is a 12B6 motion. That's not what they filed. They filed a 12B1, 2, and 6 motion. And at argument in the Superior Court, they referenced matters outside the pleading and arguing their case. It's only when they got up to the Court of Appeals all of a sudden, oh, it's a 12B6 motion. Well, it wasn't down below. It was just about sovereign immunity under 1, 2, and 6. And of course, under 12B1 and 2, you can bring in evidence outside the pleadings. The Court of Appeals treated it just as a 12B6 and ignored the rest of the motion. The problem with
One thing, I'm sorry to interrupt you, but I think one reason it kind of became a 12B6 case is that the 12B1 and 12B2 argument is sovereign immunity. And in the context of this type of claim, that sovereign immunity question is just, because it's a quorum claim, did you assert, is it a colorable claim in the allegations? And so it would be very odd to say we can put in a bunch of evidence and sort of litigate the merits of that question, because you're really just supposed to be looking at the complaint. Is it a plausible constitutional claim? And I understand your argument to be, of course it is, because what we said is we got singled out and targeted. We were very clear in the counterclaim about those allegations, and we don't look at anything other than what we've alleged, because you have to assume that everything we've alleged will be proven to be true. That's your position.
correct. I'll agree with you on the 12B6. That's the reason they kind of got there. But I'm not convinced under your jurisprudence that a 12B6 motion and under Dominski that's the same standard. It seems like it's lesser under Dominski. At least that's the way I'm reading the case, because it's a plausible claim. It's not saying you have to say everything exactly the way you need to under 12B6. But I'm not sure it matters.
Let me jump in on that. In Tully, the court says, look, all you have to plead is that there was some violation of a policy, or that there was a policy in place, rather. There was a violation of a policy, and as a result, there was some harm.
That's right.
Right? So how does that square with your reading of Deminsky and what's required? I mean, it would seem that Tully's a lower standard. And do you meet that standard with what's in your complaint and how?
I believe so, because what we alleged in the complaint is that, first of all, this is different than what you normally see. First of all, we didn't have a complaint. We had a counterclaim. But I think it's important. And it's important because the state came and made allegations. They made all these allegations. 3 of their paragraphs, which made up part of their element of their claim, was they spoke out against us. They spoke out against the governor. How could they do that? That's part of the elements of their cause of action. Normally, it is very difficult, some might say almost impossible, to prove a selective enforcement claim. It is not easy, and if you accept the standard the state has, it's impossible to prove a free your labor violation as well. But this is different. They actually said, we're going after you because you spoke out. It's an admission. They said that's why they're doing this. When they said that, we agreed with them. Yes, we'll admit to that. That's why you're going after our clients, because they spoke out against you. And when you did that, you didn't even go and use the right means of enforcing your executive order. So I believe, to answer your question, we have pled, both in our answer, which was incorporated by reference, and in the other defenses, which were also incorporated by reference, that we have met the Deminsky standard. Now, looking back, if I had known we would be here when I was drafting that counterclaim, I would have simply repeated everything I'd said before. And it makes it a lot easier if you do that, but when you're drafting, you don't want to repeat things 2 and 3 times because you get, these monstrous pleadings. So you just incorporate by reference, which is what we did. And I believe we have put in a plausible claim. Matter of fact, I think we put in more than one plausible claim.
I'd like to ask you about the standard of review for the fruits of one's labor claim. The state cites a couple of cases, Trient's and Poor Richards, for the proposition that we have essentially adopted rational basis review. And there is language in those 2 cases that does seem to a significant degree to track that federal standard. Do you think that's the standard of review? Did Trient's, did Poor Richards change the law with respect to that?
I don't believe so, and this is the reason why. Back in 1960, this court in State versus Warren set forth a test. And what it said was, the first thing you have to look at is, does the state have the police power to do whatever it's doing? Going back, what seems like 100 years ago, I was in law school. And I took this course. And it was on government, and they said, well, when you're drafting something, if you're drafting a statute, an ordinance, an order, the first thing you're going to look at is, do you have authority to do it? So in this case, what we're saying is, State versus Warren, this court looks at, do you have the authority to do what you've just done? Do you have the authority to shut down somebody's ordinary business? Our position is, no, you do not. Now, Poor Richards, and there are several other cases that talk about, was it reasonable to do what they were doing? And when you look at those, you see what they're talking about are regulations. And what this court said in State v. Warren was, well, first, you look at, is there a police power? That police power stops at regulation. In other words, the state can issue regulations. They didn't do that in this order of abatement. They shut us down. They said, we are shutting down a Speedway. We're not going to regulate you. We're closing you, period. It is important to note, I think, that had this been a reasonable regulation situation, that we would not be here today. My clients met with the health department. They gave them a list of things to do. They said, here's a list of things to do for you to operate safely. They did all of them. They complied. But the health department said, well, this is an interim list. There'll be a final one coming out from the governor. The final one came out and said, you can only have 25 people. This is a speedway that seats over 5,000 people. It is an outdoor facility. It is huge. Used to be a NASCAR track. It's not some small raceway. It's a big speedway. If you can imagine, there are grandstands going up on both sides. Over 5,000 people can get in there. If you only put 25 people in it, you couldn't even recognize the people that are there. You're so far apart.
To be fair, though,
Pardon me?
you could have said that in an allegation in the counterclaim, and you didn't, right? I mean, we can certainly look to what you admitted from the allegations in the complaint to figure out the size of the stadium and things like that. But some of what you're describing is
Some of it
outside
was outside the complaint, but like I said, when we argued this in front of the Superior Court, we're talking about 12B1 and 2, which allows for evidence to come in from outside. We submitted testimony which came in without objection from the state that was presented at the preliminary injunction hearing. So it was not, we put it into evidence. They didn't object to it. So I would submit it's there. And had they objected to it saying, well, this goes beyond 12B6, then we would have had an issue. They didn't. They allowed it all to come in. It's all in the transcript. So if it all came in at that point, how can now they say, oh, well, you can't rely on that to establish jurisdiction in the court if it came in at the trial court without objection? Going back to State versus Warren, I think it is important. If you look at the cases, they talk about regulations, they talk about statutes. You don't see the cases talking about just shutting you down. Orders of abatement that says you shall cease to operate because you have violated an executive order. As far as I know, this is the first time this has come before this court. If you were just looking at regulation, I don't believe you have the problem. It's when you shut them down, or in the King versus Chapel Hill case, you adopt something that is so onerous that you can't comply with.
I think this might be what you're saying, but so is your position that, the question, the test is, was the chosen governmental action reasonably necessary to promote some legitimate government interest? And your argument is the question of whether it's reasonable to choose to close a business rather than doing these other things is something that it is inherently an evidence-based, a fact question. So you've alleged in your complaint, or in your counterclaim, that there was no sort of rational explanation. It wasn't reasonably necessary. It was based on a bunch of illegitimate reasons. And you think you're going to prove when you get to discovery that that's actually the case. Your friend for the state doesn't think you're going to prove that, but it seems like at this stage of the case, because we have to take everything you say as true, that it's certainly moving forward to figure out who's right about that. That's your position? So in other words, you're not saying you can never shut a business down
No, I'm
in our
not
state.
saying that. Well, what
It needs to be reasonably necessary for.
Well, I think it's a little different than that. At least if you go back to your State versus Warren test, if it is a social ill, you can certainly shut the business down. Orders of abatement go to specific businesses. You don't have an order of abatement saying every speedway in North Carolina is closed. That would make no sense because you have a fact basis for an order of abatement. It's an imminent health hazard. The state has not shown anything that indicates a speedway was an imminent health hazard. They just didn't. They talk about, well, if you go and sing, it's a problem. It can spread COVID. If you have Mardi Gras and they attend Mardi Gras, that can be a problem. What we had was 3 races with over 5,300 people attending without people getting COVID. It's because of all the steps they took to prevent that.
Aren't you going to prove that with facts, and then this will be something you show at summary judgment? You forecast that evidence? I mean, there's not, because that's also not in the complaint, or
Well,
your counterclaim, right?
Right.
I'm just trying to
It
keep
is.
everybody where we need to be at this stage of the case.
Well, and yes and no. I mean, this goes back to what was introduced into the argument at the Superior Court level. What the state has said is, well, you know, all that stuff that came in, we don't think that should have come in. But they didn't accept from it, they didn't appeal it. It did come into evidence because we thought it was 12B1 and 2. We didn't see any problems with it coming in. And there was, in this case, which is unusual, there was a lot of evidence which came in a hearing.
But I guess what I'm getting at is I think the reason that typically you see sovereign immunity as B1, B2, B6
Right.
is that in many cases you do need some limited sort of quote jurisdictional discovery. You know, is there an insurance contract? It's waiving, you know, the sovereign immunity. Is there, you know, for personal jurisdiction questions, of course, you routinely get jurisdictional discovery. But in a quorum claim, the thing that waives the sovereign immunity is, have you asserted a colorable claim? And so that is a question for the allegations in the complaint, not because if you're going to say, let you do discovery and figure out if it's a colorable claim, you're moving down into the merits. And the whole point is you don't, you know, the argument is you never do the merits if you're entitled to sovereign immunity. You don't have to be hailed into court at all. So I
Normally-
think that's what was going on in this case.
Normally, when I have done sovereign immunity cases, which I've played that a lot over the years, I would always put in affidavits and insurance policies, which you have to do, in order to show there's not been a waiver of sovereign immunity. There's no, except for a very few cases, there was not any kind of discovery on that, and when there had been discovery, the judge converted it to Rule 56. So in Data General versus County of Durham, the Court of Appeals, and there's a string sign in the brief on this, has said, for purposes of determining sovereign immunity, you can look outside the pleadings. For Domensky, I think that same rule applies. I mean, it's in front of the court. The judge is looking at it to see if there's a plausible claim. You've got what's been alleged, you've got affidavits. In this case, the state was also arguing about affidavits and what had been testified to. Both sides are looking at the same thing. So I would submit that that's what I'm saying. I don't think it's exactly the same as a 12B6.
Well, but I agree with you, but what you just described, because you can certainly look for the colorable claim standard at summary judgment as well. I think you said it. If the court wants to do that, wants to get into all of that, then you have converted the Rule 12 motion to a 56, and you have to allow the parties the reasonable discovery that the rules of civil procedure permit before you would say, okay, now I'm going to show me your evidence, because that wouldn't be fair to people to do it in a fact-based way without allowing both sides to try to gather all the evidence that they can to make their claim.
Well, if the if the parties ask for discovery, it's been my experience that that's when it's converted to a Rule 56. If it's simply affidavits being presented, at least under Data General, that's fine. And the court can see, you know, has there been a waiver? Is there a statute? Or in this case, is there a constitutional claim that waives, a plausible constitutional claim that waives sovereign immunity? I would submit there is, and I believe we've pled it, and I believe there's a sufficiency of evidence to back that up. There's been enough evidence put in this record that was before the Superior Court judge that I think, you're way down the road from where you're in a normal case. I don't remember ever having a case that we had so much evidence prior to the time of deciding on a motion to dismiss. I mean, we had a tremendous amount of evidence. getting back, if I could, to the fruits of your labor and not following the statute. Kind of got away from that, but I believe that establishes in and of itself a fruits of your labor violation. Because in this case, the state did not follow the statute. The state instead chose to go criminal when there was no authorization and did not follow what the statute said. So I think that is an important case. I mean, there's really two different ways to look at the fruits of your labor claim, and I believe either one of them, I think both were pled, and I believe both of them establishes a waiver of sovereign immunity.
And isn't that like Tully, right? Isn't Tully, there's a procedure, there's a violation, and then there's harm. Here, I take it your argument is there's a statute, there's a failure to comply with the statute or going around the statute, and your clients have suffered harm.
Right.
So you mentioned earlier that, this is sort of different than your typical regulatory case. And your friend on the other side says, look, when we look at this, it's kind of rational basis plus, right? Because there's a complete deprivation here, should it be entitled to some heightened scrutiny?
Well, I think since there's a complete deprivation, I believe you fall back to the State versus Warren standard, which is you've got to look to see if there's a police power, period. There is a deprivation. There wasn't a regulation at all. It's simply you have deprived somebody, and that in and of itself goes beyond the power of the state. If you go beyond the power of the state, you have a fruit of your labor clause violation, or more importantly to say, it's your right to earn a living. Because the right to earn a living is two different sections of our Constitution. One of them, which has not been talked about a lot in the brief of the state, is the law of the lands clause. I think when you start talking about using civil remedies instead of criminal remedies, you're getting into that due process that is part of the law of the lands clause, which makes up your right to earn a living. It's both of them. They talked a lot about the history of the Fruit of Labor Clause. They didn't talk about the Magna Carta, which obviously is where our law of the lands clause come from. The Magna Carta was enacted to keep the king from using certain powers to simply deprive the people of their rights. The rights to property, the rights to work, the land that they had. That's what we have here, I think, is we have the state depriving people of the right to earn a living.
Let me just make sure I understand the implications of your argument here. So you're saying that even if there was a public health problem with people gathering in these numbers, that the state could not protect the public by stopping the gathering. The state could only criminally punish whoever's responsible for holding the event.
No, I'm not. No, Your Honor, if I could, Justice Earls, let me talk about a case that is not in the briefs,
Sure.
Which actually is an illustrative of what you can do, what the state did do. There was a case called, I believe it's Smith versus Cooper, which involved gyms. It was a business court case. Everything was transferred to the business court for a long time. That was the COVID cases. And that was the one where they shut down the gyms. During argument, the state said, we really didn't mean to shut down the gyms. We really meant only to regulate them. What did they do next? They actually adopted rules as to when gyms could operate and how they had to operate. They adopted the regulations. So if you have, let's say the speedways were causing a problem, the state certainly can come in and then DHHS can promulgate rules and have public hearings on those rules, and then they could enforce those rules. That wasn't done here.
And there wouldn't be any timeliness problems? I mean, how?
There was not in the gyms case. Actually, they did them within a couple of weeks, I believe, because you can adopt an emergency rule. You do emergency rulemaking, which has to be followed up with your normal procedures, but you can do an emergency rule, which is done in a matter of days. So that can be done. There are ways of doing this. It's simply the state didn't follow the established rules that are set forth in the general statutes. This isn't saying, no, the state is powerless to protect the people. The state can protect the people, but there are procedures to go through to do that, and they didn't use them.
And again, just to be clear, your allegations are that was not the reason that your client's business was shut down anyway. Your allegation is that your business got targeted and shut down your client's business because the government was upset about things that your client had done, the way your client was speaking about the restrictions. And
That's
that
correct, Justice.
there were many other similar businesses.
Yeah, this is just
government.
answering Justice Earle's question
Right.
as to
Right,
the
but that's the,
hypothetical.
here, if you were to look at the four corners of the counterclaim, that's the claim that you focused on and say, we're stating a claim, we're getting past sovereign immunity on this ground.
Yes.
Does your fruits of your labor claim depend on the selective enforcement claim? That is, can you win your fruits of the labor claim if you fail to prove and a court fails to find there was selective enforcement?
I believe we can, because there's also the argument that there is no rational basis for what they did. And I don't think there is. Even if you get beyond the police power claim that we've made, we've also briefed that there is no rational basis. There was no one getting sick at the Speedway. They had implemented all the regulations except for the 25-person limit, which we believe was irrational because they had no basis for putting in the 25-person, which deprived my clients of their ability to make a living. So yes, I think we could prove that even without the selective enforcement. The selective enforcement makes it a lot easier that they have gone and alleged that they are going after them because they talked to the press and criticized the governor. Makes it a lot easier to prove the case, but you don't have to have that. Well, my time is up. I will stand on my brief as to the remaining issues. Thank you.
Thank you, Mr. Kitchen. We'll hear from rebuttal.
Thank you, Your Honor. 3 quick points, if I may. First, on the statutory question, I don't think, with due respect, it's reasonable to read the Emergency Management Act as setting forth an exclusive set of remedies. The very first words of the Act are, in addition to any other powers conferred upon the governor by law, and then it goes on to enumerate powers. The section heading is additional powers of the governor during a state of emergency. That same language appears later in the statute when it discusses the local conditions powers. It says, in addition to any other powers conferred upon the governor by law.
But 130A-20 doesn't confer powers on the governor. It confers powers on the secretary.
Well, of course, Your Honor, but the secretary is a part of the governor's administration. I think that is reasonable to read that statute as when a governor's cabinet official has certain authority, that is encompassed under the governor's authority. And the last part of the statute I'd point you to would be the violation language. It does say that it's a Class 2 misdemeanor to violate the governor's emergency orders, but it doesn't say that that is exclusive. And I'm not aware of any canon of construction that says a criminal remedy set forth in a statute means that the civil remedies are impliedly excluded. The second point I'd like to make relates to the allegations in the counterclaim. Of course, the challenger bears the burden, as always, to set forth colorable allegations of a violation of law. And there's nothing unusual about an abatement order that temporarily requires a business to take some actions or to pause its operations until a public health risk is removed. So this is not a ban. It's not banning a Speedway from operating its business. It was a pause for the summer of 2020, which it bears noting was more than a year before this court allowed in-person oral arguments. This abatement order was lifted, and in the summer of 2021, ACE was racing because there were no restrictions at that time. And I think the final point, again, is that these were extraordinary times. We all understand that. And the political branches stepped up with extraordinary amounts of financial relief for affected individuals and businesses. So a financial comparison, I think, is instructive. The around $24 billion in funds were expended to individuals and businesses from the state and federal government who were affected by the pandemic. That's equivalent to the entire state budget in 2019. They didn't intend it as such, but these programs effectively served as a judgment fund because everyone in society was affected by these regulations and suffered financial hardships, and they could seek compensation from the government. And that's...
You're almost out of time, and I do have one question before you run out. So in your view, is it the trial court's order, 12B1, 12B2, 12B6, what was going on there? That seems to be somewhat important. You heard your friend pointing that out. What did the trial court do?
I'm sorry if I could...
So, there was their argument was 12B1, 12B2, 12B6. We thought it was just all of it at one time. What did the trial court's order do? What type of order was it?
Oh, my understanding is it's a 12B1, 12B2 sovereign immunity, but informed by the Dominski standard, which is essentially a plausibility analysis.
Thank you.
Thank you, Your Honor.
Counsel? Mr. Clark?